Hello, thank you for joining me. Today we are going to talk about how to protect your children's future when you are not here to guide them. Many of our younger clients tell us that they don't think estate planning is necessary. They believe their spouse would take over if they were gone, or they have family members that live close to them and would automatically step in to help. Why do we believe it's important for young families to plan? In your estate planning, that is where you can appoint a guardian for your minor children. You can guarantee your children's financial future by setting out plans for how to use your funds. You can personalize those solutions for the needs that you want to prioritize for your children, and you can avoid probate court. Here's a question for everyone. Think about this for a second. What would happen to your children if something catastrophic happened to you? What would happen right now? Let's play this out for a moment. Let's say you and your partner are out for a night. Babysitter is on duty. Think about all the things you've done to prepare for that one night out. You've left a list for your babysitter of things that your children can and cannot eat, things that your children can and cannot do, books that your children can read, maybe books that they can't read, movies that they can't watch, movies that you'd recommend. You've let the babysitter know where you are, how to reach you, how to reach your neighbor. All these instructions for one night out. You've prepared for the unexpected. So, what happens if you didn't prepare for the ultimate, which is that you don't come home? We understand that most people would answer this question by saying they have family members and friends that would step in automatically. Unfortunately, that's not enough. If the Vermont Department of Children and Families are notified, what they are worried about is, are those children safe? Are they alone? And is there a legal guardian in place? You need to leave instructions about legal guardians, or else the court has to make sure that happens. And that means that the court is involved. What does a guardian mean for each person, though? What is a suitable guardian? That's a question that's going to be relative, and each person's going to have a different answer for that. And the court will have their own opinion about that as well. Long-term guardianship proceedings that result in permanent appointments can be rigorous, expensive, complex, and lengthy. Courts are going to provide oversight, and courts are required to listen to anyone who appears, who believes they have uh, an interest in what's going to happen to the children. The court has to sort out any kind of family mess that's presented to them. And what about funds for your children? Funds to care for them. Even if you've named a guardian to take care of your children in a will, that doesn't mean that your assets are going to be used to provide for the children in the way that you would want that to happen. The will might direct funds to your children, but then the probate court will have the oversight to determine what actually happens to those funds. Why should you avoid probate? We believe our clients should avoid probate for guardianship proceedings, but also for just regular estate planning proceedings. It can be expensive, it's time consuming, you will need the court's permission to do anything. It is a public proceeding, and if there's property in more than one state, there are going to be multiple probates. Step by step, here's what happens. You have to give notice to all interested parties. That means any heirs have to be tracked down. Any potential heirs, that is. The probate court is a forum to resolve disputes, so any interested party has a say. Creditors need to be paid, and there has to be a public notice to those creditors. You definitely have to do an inventory, and you might have to do an appraisal of certain assets. You may have to post a bond. Tax clearances can really hold up estates. And in the end, there's a distribution of an estate. But think about it. If you don't have the proper instructions, there could be outright distributions to really young adults, 18-year-olds, 19-year-olds, and so on. What happens when teenagers manage money when they inherit a big lump sum? Most are not equipped to manage their own money. And if a parent passes away without leaving directions on how assets should be managed and used, the court will make an outright distribution for the 18-year-old and let them fend for themselves. What's the solution to this picture that we have painted? Today, we're going to show you how to protect your children, even if you are not around to do it. Let's talk about guardians and how to appoint them. What makes a good guardian? You really should examine all of these subjects before you actually decide who to appoint in your documents. You should think about things like parenting philosophies. Religious beliefs may come into play. Location and geography are very important issues to think about. You should think about discipline styles and what are your personal values and your personality type, and how do your children react to these types and other types. One of the things about probate court and a guardianship proceeding is that the children are going to be involved, and it can be very stressful. Is there anybody that you don't want them to be on, don't want to be on your guardian list? You should think about that and make sure that you name people that are suitable so the court doesn't have a chance to name anyone else. We recommend a guardian journal. This is an organized journal where you give details on your day-to-day so that a guardian appointed potentially in the future would know what to do. For example, the name of doctors, details about their schooling, daily routines at your home. We often tell our clients when we sit down to meet with them about estate planning, they should really examine this question. What is it that you want to protect? Who is it that you want to protect? How do you want your assets to be distributed? And to whom do you want them to go to? And who do you want to protect in terms of unplanned circumstances? If there's a divorce, if there's lawsuits, and what do you want to do with your funds if your minor children happen to receive them? A trust is like a tube of toothpaste. Anything that is out of the tube is not going back in. So when you do a trust, it's important to think about how the distributions are going to be made, especially when we're talking about minor children. A good estate plan protects your family's financial future, and we believe a good estate plan will involve a trust where you can get as detailed as you need to. You can prevent your children, your minor children, from getting direct access to assets, and you can even protect young adults or older children from having direct access if that's something that won't be beneficial to them. Money can be used for health, education, living expenses, and the trustee will manage those things for the minor children or the young adults, and you don't have to have that court oversight. A trust can protect families against divorce and keep money in your family and not going out to others. And you can keep inheritances safe from creditors, con artists, and lawsuits. Remember, not all families look the same. Your family dynamics, your family makeup will impact your planning needs. It is important for each family to think about how their children can be impacted if you are no longer here. Each family will have unique concerns. If there's a single parent, then no one is there automatically to care for your children if you die or become incapacitated. Blended families. Who is the right choice for a guardian or trustee, a current spouse? Is it the child's other parent, or is it your new spouse? Is it someone else, some third party? Unmarried partners give no legal rights to the other person's assets. How do you want to manage that? Married with shared children, there's an automatic backup plan in place, but what if something happens to both of you? And then we'd like people to consider parents of children with special needs, whether it's special health needs or mental health needs. If a child inherits assets from you, they could lose important government benefits that they've been receiving. And if you're sharing custody as co-parents who are divorced, who's the legal guardian if one parent dies? Who will manage the money for that child? How do you keep it protected from future marriages and the like? If you're interested in meeting with an attorney to start your own estate plan, please contact our office. We appreciate you watching this video.